Okay, we're going to get through Chapter 2, Cohabitation and Premarital Agreements. Again, anything that is in your text or covered in lectures or anything that I may now or in the future post to discussion boards is fair game for the test, as well as anything that's on your vocabulary quiz, so keep that in mind. My lectures are really just designed to help get some overall familiarity with the subject area, but I really do want you to, because we don't have an in-class lecture, an opportunity for open discussion, I want you to dig into the materials and understand all of the concepts that are in there. So, having said that, let's get into Chapter 2. After reading Chapter 2, you should be able to define cohabitation, identify various kinds of documents cohabitating partners can use to create and protect their rights, explain what a cohabitation agreement is, identify forms of relief potentially available to cohabitating partners if their relationship terminates, describe the nature and purpose of a premarital agreement, identify commonly accepted legal requirements for a valid premarital agreement, list the kinds of provisions a basic premarital agreement contains, identify trends regarding the enforceability of premarital agreements, describe the paralegal's potential role with respect to cases involving cohabitation and premarital agreements. So, defining cohabitation. What is cohabitation? Cohabitation is broadly defined as two unmarried persons living together commonly in an intimate relationship. How it differs from marriage is that the parties do not have to satisfy any legal requirements to cohabitate or to cohabit. Cohabitation can be terminated without legal process. There is no presumption of parentage when a child is born to a female partner in a cohabiting couple, and hence no duty of child support or right to visitation. If the relationship terminates, division of property may be based on an agreement of the parties or based on equitable relief provided by the courts. Following termination, absent an agreement to the contrary, there is no duty of support. Identify various kinds of documents cohabiting partners can use to create and protect their rights. So documents to create and protect their rights, some of the things that they may want to consider are healthcare proxies, durable powers of attorney, wills, deeds reflecting joint ownership of property with rights of survivorship, life insurance policies, trusts, beneficiary designations on retirement accounts, etc., joint partnership agreements, cohabitation agreements. If you recall, the example from your book discussed a cohabiting couple, and then one went into the hospital and all of the attendant circumstances that came up where the partner that was not hospitalized had really no rights to access to healthcare information or anything else, really. It sort of opens your eyes to all of the possible pitfalls of cohabiting without a marital contract or a cohabitation agreement. So take a look at that example. It really is an eye-opening view at how some of these things happen, and particularly prior to the recognition of same-sex marriage, these were issues commonly faced by same-sex couples, so something to take a look at and consider. Explain what a cohabitation agreement is. A cohabitation agreement is an agreement between two unmarried individuals who live or intend to live together, defining their intentions, rights, and obligations with respect to one another while living together and upon termination of their relationship. A cohabitation agreement is a contract, and the sole consideration for the agreement must not be meretricious sex or prostitution, what would otherwise be prostitution or sexual relations outside of marriage. Your book goes into that in more detail as far as specific language to avoid when you're putting in language in cohabitation agreements, to make sure that there is some other consideration given for the contract. Obviously, you have to have a benefit and consideration in order to have a valid contract. So anyway, take a look at the chapter with respect to meretricious sex and the issue of contracting prostitution, essentially, in cohabitation agreements. Cohabitation agreements allow parties to privately identify, negotiate, and reach agreement with respect to their expectations, both financial and personal. Cohabitation agreements are similar to premarital agreements in some respects, but are usually not as comprehensive. There is a section application 2.1 on pages 27 and 28 of your textbook that gives you a description of some of the common provisions utilized in cohabitation agreements. It's by no means exhaustive, but certainly some of the more commonly used terms and conditions. So take a look at those. Cohabitation agreements may include provisions about expectations of the parties regarding their relationship, but an individual provision of a cohabitation agreement or an entire agreement may be held unenforceable if it violates the law, constitutional right, or strong public policy, such as a provision that a party who gets pregnant agrees to have an abortion. Clearly against public policy, and would at least that provision would be held unenforceable, and potentially the entire contract. Identify forms of relief potentially available to cohabiting partners if their relationship terminates. You can look at the Marvin v. Marvin case, which popularized the term palimony, which is court-ordered allowance paid by one cohabitant to another after their relationship terminates. Without abandoning the strong public policy favoring marriage, the Marvin court endorsed the now widely held principle that when the facts warrant it, the court should fashion appropriate equitable remedies for cohabitants to avoid hardship or injustice. How does the court do this? The court has a couple of different ways that they have justified doing this over the years. Exhibit 2.2 on page 33 to 35 of your text will give you some more in-depth information on these things. But the court can utilize an express contract if the parties actually articulate an agreement. That would be an express contract the court can use to enforce the rights of the parties. An implied in fact contract is where the court infers the parties' intentions from their conduct and the surrounding facts. So there is no actual written contract or oral contract, but the court infers such a contract by nature of the parties' intentions, or by the nature of the parties' conduct and how they've held themselves out and conducted themselves throughout the course of the relationship. There's also the theory of quasi-contract or implied in law contract. This is where the court creates the contract to avoid unjust enrichment of one party at the expense of the other. Major legal basis for granting relief: purchase money, implied or resulting trust. The court creates a trust when one party contributes the funds for purchase of a property and title is held in the other party's name. So the trust would be held for the benefit of the party who has no actual property interest in the property, but has a legal obligation on a debt for the property. A constructive trust: the court imposes a trust on an asset of a party who wrongfully obtained the asset. The trust is for the benefit of the wronged party. Implied partnership or joint venture is where the court creates a partnership based on the conduct of the parties and distributes the assets and liabilities of the partnership based on principles of fairness. And the putative spouse doctrine, in which the court provides relief to a person who reasonably believed he or she entered into a valid marriage. So say, for example, one party was already married to another spouse who they never went through the process of terminating the relationship with legally. The second marriage would be, void ab initio would be a void marriage. However, if the spouse was unaware of the existence of the first marriage, then technically, legally, there was no valid marriage, so no valid second marriage. So the second spouse would be entitled to essentially just civil damages, as opposed to the rights and privileges afforded to married couples that are terminating a relationship. And so the court, under the putative spouse doctrine, allows that innocent party to receive the same protections that the domestic relations law provides, utilizing that doctrine. Describe the nature and purpose of a premarital agreement. A premarital agreement is an agreement made by two persons about to be married, defining for themselves their respective rights, duties, and responsibilities in the event their marriage terminates by death, annulment, separation, or divorce. The big case on premarital agreements is the Posner case. It was decided in 1970. You can find the information on the Posner case on pages 36 and 37 of your text. The Posner case has said, with divorce, such a commonplace fact of life, it is fair to assume that many prospective marriage partners might want to consider and discuss and agree upon the disposition of their property and alimony rights in the event their marriage, despite their best efforts, should fail. A tendency to recognize this change in public policy is clearly discernible. Postmarital agreements, however, postmarital agreements are agreements made by two people already married to each other who want both to continue their marriage and also define their respective rights upon separation, divorce, or death of one of the spouses. Banned in a small minority of states, Ohio is one of those states that typically does not recognize postmarital agreements. Separation agreements. Separation agreements are agreements made between spouses in anticipation of a divorce or legal separation, concerning the terms of the divorce or legal separation and any continuing obligations to each other. Typically, with separation agreements, a lot of times people think that these apply in cases of legal separation. However, what we do in divorce cases and dissolutions, in any termination of the marriage where we are doing it by agreement, is we will draft a separation agreement, which is the document that outlines the respective rights of the parties, the disposition of the property and the assets. If there is going to be a shared parenting plan, it will incorporate the shared parenting plan by reference, and then a separate shared parenting plan is filed. But the separation agreement is the document that outlines spousal support, property division, allocation of parental rights if it is not included in a separate shared parenting plan. So it's really the document that outlines how the marriage is going to be terminated as far as the disposition of the property and marital estate. And then once the parties have agreed and signed, the court will incorporate that separation agreement by reference into their final decree. Identify commonly accepted legal requirements for a valid premarital agreement. The requirements for a valid contract, the requirement of procedural fairness, the requirement of substantive fairness. So take a look at those in your text, but we're going to run through them quickly here. So the requirements for a valid contract: there must be an offer. The offer must be accepted, generally in writing. The parties must have the legal capacity to contract in terms of age and mental competence. The subject matter of the contract must be legal. There must be consideration for the contract, which is, consideration is also known as, consideration definition is a bargain for exchange of something of value. So you're getting something and giving something in return. There must be a meeting of the minds, which is a shared understanding of the terms and conditions of the contract. With no meeting of the minds, there is no contract. That is a very core contractual concept to remember going through in all of your courses. If there is no meeting of the minds, there is no contract. The parties have to clearly understand the terms of what they are entering into. The requirement of procedural fairness refers to fairness in the negotiation and execution of the agreement. Examples of procedural fairness include the following: representation by independent counsel. One attorney cannot reasonably represent the interest of both parties. Adequate disclosure of assets and liabilities. Did the parties have or should they have had knowledge of each other's worth such that each could make an informed decision? Sufficient time to negotiate and review the agreement prior to the execution. The states vary with respect to what constitutes an appropriate time. There's a lot of examples you'll see of people being rushed to sign a prenuptial agreement the day before the marriage, or sometimes the day of. And there must be absence of fraud, duress, or undue influence in the negotiation and execution of the agreement. Substantive fairness refers to the fairness in the specific terms of an agreement. So the procedural fairness is fairness in how the document came to be and was executed. Substantive fairness is fairness of the terms of the contract itself. So examples include: is the division of property per se unfair or unconscionable? Is an agreement to waive alimony or spousal support fair? The states vary with respect to whether fairness will be measured only at the time of the execution or also at the time of performance, which is also known as the second look approach. Most courts will not enforce the agreement if its terms are so unfair to one of the parties that they are unconscionable, meaning that they, quote, shock the conscience of the court. List the kinds of provisions a basic premarital agreement contains. All agreements vary in length and formality, but generally they include the following basic components: a preamble, or an introductory segment, a definition of separate property and how it will be treated. Separate property is any property that the parties brought to the marriage, or any property that is inherited by one but not both of the parties during the course of the marriage. And there's a few other instances of separate property, but typically it's going to be the property that the parties bring to the marriage. It's going to be the subject property that the parties are seeking to protect from the other party in case a divorce occurs. A definition of marital property and how it will be treated. A statement of the rights each party will have to spousal support if the marriage terminates in a separation or divorce, or a waiver of those rights. A provision relating to death benefits or a waiver thereof. General provisions, meaning which would include severability, governing law, etc. Severability would be that even if the court were to find that one provision or one or two or more provisions of the contract were unenforceable, that doesn't necessarily invalidate the entire contract. Governing law is going to state, for example, that the contract is going to be governed by the laws of the state of Ohio, etc. Schedule of assets and liabilities. These are often attached as exhibits, but these are going to spell out what that protected property is. And there is an example of a premarital agreement on pages 43 to 53 of your text for a model agreement. I always encourage you to take a look at the forms and examples that are in your books, because they really give you an idea of the general sense and tone of the agreements, and also give you a good indication of some of the core sort of boilerplate language that's often included. The parties cannot agree to engage in criminal activity. These are red flags in premarital agreements, so things to keep an eye out for. These are things that cannot be contracted. So the parties cannot agree to engage in criminal activity. Although they may include child-related provisions, the parties may not bargain away their children's rights to child custody and support. They should be advised not to include terms that tread on constitutional rights, to have and raise children, to freedom of religion, etc., that may taint the entire agreement. They may not agree to prosecute or not defend a divorce action. As non-spouses, they may not waive ERISA-governed pension rights in their agreement. Identify trends regarding the enforceability of premarital agreements. The Uniform Premarital Agreement Act, the UPAA approach, adopted in whole or in part in about half of the states, is designed to create uniformity and increased enforcement of premarital agreements through application of ordinary contract principles. The UPAA approach generally favors enforcement unless the party against whom enforcement is sought did not execute the agreement voluntarily, or the agreement was unconscionable when it was executed and before execution. The party against whom enforcement is sought was not provided fair and reasonable disclosure, did not waive in writing such disclosure, and could not reasonably have had adequate knowledge of the property and financial obligations of the other party. So the general rule used to be that married parties could not contract, and that is why Ohio doesn't recognize postmarital agreements. They do recognize premarital agreements. Initially, when premarital agreements started garnering favor and being utilized, they weren't favored in the law. They weren't something that courts really liked to enforce, because the idea was that having a premarital agreement was sort of anticipation and preparation for divorce, and so it helped to perpetuate divorces and almost encourage the divorce process, because people knew there was no significant downside to getting a divorce because their rights were protected prior to ever entering into the marriage in the first place. Again, public policy has sort of shifted. Societal attitudes toward marriage and premarital agreements has shifted, and so the states and the courts are now utilizing and enforcing premarital agreements more than they had in the past, and it becomes it's almost routine practice now with any parties who have substantial assets to enter into these agreements. However, having said that, the courts still want to make sure that the disadvantaged party, the party who is going to be walking away from the assets, does so knowingly, voluntarily, and with the benefit of legal counsel. Enforceability of premarital agreements. The traditional fairness approach treats premarital agreements as contractual agreements between people who bear a special fiduciary relationship to each other, and therefore holds them to a higher standard than contracts between strangers dealing at arm's length. This is essentially a fairness approach. Several states have adopted the second look or second glance doctrine to determine if the terms of an agreement that may have been fair at the time of the execution remain fair at the time of performance. The contemporary freedom to contract approach treats premarital agreements as basic contracts. People are free to make bad bargains, and a person cannot avoid performance of a contract simply because it seems unfair, unreasonable, or to him or her to his or her disadvantage. Absent fraud, misrepresentation, or duress, agreements will be enforced unless enforcement will bring about an unconscionable result. You can look at the Simeon case on pages 56 to 57 for an example of a case in which the court applied the contemporary freedom to contract approach. Describe the paralegal's potential role with respect to cases involving cohabitation and premarital agreements. The paralegal's role will largely depend on whether the case involves negotiation and execution or enforcement of an agreement. Typical tasks may include participating in client meetings and taking notes, gathering necessary information and documents, researching governing law, researching forms of agreements, drafting and reviewing agreements, preparing related correspondence, making arrangements for obtaining affidavits of competency, drafting discovery requests, preparing exhibits for use in negotiation, at trial, etc. For more detail on the specific tasks the paralegal may perform, you can look at Paralegal Application 2.2, 2.5, and 2.7 in your text. So, again, running through the goals for this chapter, you should now be able to define cohabitation, identify the various kinds of documents that partners can use to create and protect their rights, explain what a cohabitation agreement is, identify forms of relief potentially available to cohabitating partners if their relationship terminates, describe the nature and purpose of a premarital agreement, identify commonly accepted legal requirements for a valid premarital agreement, identify forms of relief. We already did that, did we not? Wow, they had that in there 2 times. Strange. Anyhow, so we are finished with Chapter 2, at least my review of Chapter 2. I encourage you to go back and review some of the paralegal application examples and look closely at the specific terms, the word bank at the end of the chapter. I will certainly obviously be testing on some of this information in the upcoming midterm, and I will be posting subsequent videos for chapters 3, 4, and 5, so stay tuned. Have a good day.